Diane Shaffer versus U.S. Steel. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, let me know if you do and how much time you want. When you take the podium, I'll do my best to keep track and let you know when you're getting close. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. We have read your briefs and we are ready to proceed with more. Oh, no, we're not. Give me a minute. I got to reset the clock. I'm guessing you want more than 6 minutes. Yeah, we are ready to proceed when you are.
May it please the court. And at the outset, I'd like to reserve 4 minutes for rebuttal.
Thank you.
Good morning. During my brief time today, I want to really stress 3 points on this Shaffer appeal. The first argument, again stressed in our brief, is that the trial court applied the wrong substantive law to my client's Jones Act and unseaworthiness claims. He applied, in violation of well-established, decades-old Supreme Court precedent, state substantive law to my client's claims that are rooted in federal law, both the Jones Act and unseaworthiness. Because of that error, the court applied the wrong standard, causation standard, to my client's 2 claims, the Jones Act and the unseaworthiness. And had he applied the correct standard, we believe that plaintiff, under the summary judgment standard, should have prevailed. Even under, and this is number 3, even under the correct causation standard that the court applied, we believe the evidence was more than sufficient to prevail on summary judgment as to the causation issue, which was the issue that was formed the basis for the summary judgment. Quick background, Mr. Shaffer was an employee of U.S. Steel for roughly 3 years in the early 1960s, a division of U.S. Steel, Pittsburgh Steamship. He served on 4 vessels. The U.S. Coast Guard discharge papers evidence the years that he was on those vessels. During discovery, we obtained the specs for at least some of those vessels, and they showed extensive use of asbestos-containing pipe insulation and boiler powder and packing and gaskets. Mr. Shaffer was a fireman and a coal passer. He testified during that 3-year period. It was a regular duty of his to repair and remove pipe insulation, to repair and remove packing and gaskets, and to mix and apply this cement. Plaintiffs put forward 3 different experts, none of whom were excluded or struck by the trial court. A merchant marine expert, a Captain Lowell, who had decades-long experience in the merchant marines, including experience on Great Lakes vessels during roughly the same time that Mr. Shaffer was aboard those vessels. He talked about the likelihood of asbestos work for someone in Mr. Shaffer's position. We had an industrial hygienist by the name of Jerome Spear. He assessed the significance of the exposures that Mr. Shaffer testified to from an industrial hygienist standpoint, and said that they would have routinely exceeded safe limits. And then Dr. Maddox, a pathologist out of Newport News, Virginia, who talked about the medical significance of those exposures and how routine exposures to insulation, packing gaskets, and boiler cement would have contributed to cause Mr. Shaffer's mesothelioma. And in the course of the summary judgment, he was given 3 hypothetical scenarios in an affidavit matching Mr. Shaffer's exposures to both insulation, gaskets and packing, and boiler cement, and testified that each one of those would have been substantial factors in causing Mr. Shaffer's mesothelioma. Obviously, we're here today because of this summary judgment that was granted, so we're looking at a de novo level of review. Now, on this first point, the applicable law, it's helpful to remember on the outset here, Mr. Shaffer is suing his employer for these exposures. He does not have that claim under Ohio law. These are purely federal creations, the Jones Act and the unseaworthiness claims. And the Supreme Court, dating back to Garrett v. Moore McCormick in 1942, and then in 1953, Pope and Talbot, has emphatically and unequivocally stated that federal maritime law is the substantive law that courts must apply to these types of claims. And appellee in their brief didn't cite to any authority distinguishing or saying that somehow those are no longer valid precedents. And in fact, when you look at the state courts and how they've assessed those claims, I cited to a Pennsylvania Supreme Court case, Lloyd v. Victory Carriers, which said, it's settled beyond question federal maritime law must govern all substantive matters, regardless of whether it's brought in the state or federal court. And the Ohio Supreme Court, in the Brown case, said we are bound to follow the decisions of the Supreme Court of the United States with reference to the application and construction of the Jones Act. So really, I don't think there's any debate, and it's also telling that both parties, both appellant and appellee in the Supreme Court briefing, briefed the case under federal maritime law. No party was urging the court to apply state substantive law to these causes of action. And the reason it's significant is that you've got two different claims here, the Jones Act and the unseaworthiness claim, and they have different causation standards. So the Jones Act is, because it was of its nature, it was passed as to help seamen out, it has what's called a however slight standard. Plaintiff need only show that defendant's negligence, however slight, contributed to cause plaintiff's injuries. And the unseaworthiness is a little different. It's basically a substantial factor test. It's different than the Ohio substantial factor test, and we'll talk about that. But instead of applying the federal maritime standards, causation standards for plaintiffs' two separate claims and the different ones, the trial court simply applied the Ohio causation standard to both the Jones Act and the unseaworthiness claims. And so, if you look at the Jones Act claim, first of all, it was telling again that U.S. Steel did not move for summary judgment on the grounds of causation for plaintiff's Jones Act case. So, right there, I think, and we quoted State v. Port of Common Pleas, the 905 Northeast 2nd, 1192, has long been recognized that it's reversible error to award summary judgment on grounds not specified in the motion for summary judgment. U.S. Steel didn't move for summary judgment on plaintiff's causation for the Jones Act claim. In any event, the trial court noted in its order that it was going to reject the Jones Act's however slight causation standard in favor of the Schwartz causation standard from the Ohio Supreme Court. And we talked about why that is error, but the Jones Act causation standard is however slight. It's been referred to as a featherweight standard, and that's because this is remedial legislation. And I think that our evidence here satisfied that. We have exposure over 3 years to pipe insulation, packing and gaskets, and boiler cement. And per Ohio Rule of Evidence 705, we submitted our causation standard, or our causation expert's testimony in the form of a hypothetical based on the causation or the exposure facts. And Dr. Maddox opined on each of those types, not just one, but each of those 3 types of exposures were a substantial factor in causing Mr. Shaffer's mesothelioma. The U.S. Steel's response in their briefing was, well, even though the court didn't rejected the Jones Act causation standard, they nevertheless applied it somehow, unwittingly, I guess. And, the order speaks for itself. It says that we are rejecting the however slight standard contained in the Jones Act. So if they're rejecting it, I don't see how they could have applied it. But in any event, what the court stated later was that there was no evidence that Shaffer was exposed to asbestos and it caused his mesothelioma. Again, I think the language of the order is telling, because he said in making that assessment, Captain Lowell and Mr. Spear's testimony was, quote, unconvincing. And that is telltale of a weighing of the evidence to say, not that I exclude or strike these experts, but that I find them unconvincing. And I think that invades on the province of the jury. And then the court also said, noted that there was a failure of Dr. Maddox to testify that Shaffer's exposure to asbestos while on United Steel ships was a substantial contributing factor, and that's fatal to his federal claims. Again, it's not consistent and is in fact impossible to reconcile with the record, given that Dr. Maddox laid out in response to hypothetical questions in an affidavit that each of those types of exposures were substantial factors. So then we get to the unseaworthiness claim, and the argument there is, well, the federal maritime standard is a substantial factor standard, and the Ohio court under Schwartz is a substantial factor, and therefore, even though the trial court didn't apply the federal maritime law, that he got to the same place because they're both substantial factor tests. But if you look at the law, that's a specious argument, because we think that the governing maritime law would be the Sixth Circuit's case in Miller v. American President Lines, and they specifically rejected the frequency, regularity, intensity, and duration tests that the Ohio Supreme Court adopted in Schwartz. And so that's a key distinction right there. In Miller, basically what the court, the exposure and causation evidence was that there was evidence of asbestos on the plaintiff's ship, and there was a doctor who said that any exposures can cause mesothelioma. We had far more than that. There was not, importantly in Miller, there wasn't Dr. Maddox. There wasn't a pathologist who said, I've looked at the exposure facts for this product, and it caused his it contributed to cause his mesothelioma. So we had more than what the governing standard in Miller deemed sufficient. And so had the court applied Miller, we think that we should have prevailed under summary judgment. The court cited to some federal authority, and appellee is latching onto that and saying, well, look, he did cite to some federal authority.
Counsel, I'm sorry, I just want to let you know you're 2 minutes and 50 seconds.
Oh, left. Okay.
Yeah, sorry.
That's okay.
I was busy listening.
Quickly, the trial court did cite to some federal authority in assessing the unseaworthiness claim. The Lindstrom case, the Stark case, the Crick case, and the Shelton case. None of those dealt with Jones Act or unseaworthiness claims. And I spent a lot of time on that on the brief, and so I won't, but I think they're all distinguishable. In any event, had the court, even getting past the fact that the court applied the wrong substantive standard to the Jones Act and the unseaworthiness, even if we get to that point, we think the plaintiff's evidence was sufficient under the Schwartz case in Ohio. In Schwartz, you had all the plaintiff could show in terms of exposure was that he did 5 to 10 Bendix brake jobs, and then they had an expert come in and say, I think any exposure to asbestos is a substantial factor. That was the facts in Schwartz that the court said was not sufficient. Again, here we have exposure over a 3-year period, and unlike Schwartz, and the big point Schwartz made about the plaintiff's expert was that the doctor did not testify that Kathleen's exposure to asbestos fibers from defendant's product was a substantial factor in causing her disease. Here we have a pathologist who has identified actually 4 different products on board these U.S. Steel vessels that were a substantial factor. So you have a 3-year period versus 5 to 10 brake jobs, and then you have actual testimony from a medical causation expert linking the mesothelioma to exposures aboard the U.S. Steel vessel. So I'll reserve, I guess, the rest of my time for rebuttal, but again, I think the wrong law was applied, and then that law was applied incorrectly. Thank you.
Please the court, good morning, if we're still in the AM. My name is Matthew Mendoza. I'm here for the FLE, United States Steel Corporation. We are asking this court to affirm the decision of the Lorain County Court of Common Pleas granting United States Steel's motion for summary judgment on plaintiff's federal claims and denying plaintiff's motion for reconsideration of the court's grant of that summary judgment motion. In the brief, the appellant has presented 3 assignments of error, and the argument basically tracked those. All of those assignments of error should be overruled in this case. The substantial factor test of Schwartz was applied by the court, but that test didn't apply Schwartz. He applied the substantial factor test of Schwartz in a maritime case. And there are numerous cases, federal cases, cited by both sides that say that substantial factor, when you're talking about unseaworthiness claims in the maritime context, is the proper test. And the trial court cited some of those same federal decisions too. So the test was the right test, and as it relates to the unseaworthiness claim, and is properly used in an unseaworthiness maritime claim. The trial court did appropriately and properly apply the featherweight standard of causation to Shaffer's Jones Act claim and found no evidence of exposure. I'll just briefly pause there. U.S. Steel certainly argued in the summary judgment motion that the appellant's counsel just got up and said U.S. Steel did not argue causation as it relates to Jones Act at the trial court level in the summary judgment. We certainly argued, and the court can go and look at our summary judgment papers, that there was no evidence of exposure to Mr. Shaffer, particularly in light of Mr. Shaffer's own testimony, which we'll hit on again here. But arguing no exposure is arguing no causation. So that argument was made, not in the context of Schwartz, because at that time, Schwartz had not yet been decided by the Ohio Supreme Court. It was still between the Court of Appeals and the Supreme Court.
But was there a chance to rebrief at some point in time on your summary judgments after Schwartz was decided?
Well, we did argue on the briefing on motion for reconsideration the Schwartz issues at that time, Judge. And interestingly, there was a party that argued Schwartz on the summary judgment phase, and that was the plaintiff. The plaintiff, in their opposition to United States Steel's summary judgment claim and trying to argue that substantial factor existed as it relates to unseaworthiness, cited the Schwartz case. So if you look at the last page of their summary judgment opposition, you'll see a discussion of the Schwartz case by the plaintiffs. So the very first person to discuss Schwartz in this case were the plaintiff's counsel, not the judge and not U.S. Steel, which goes to an argument that we have in our brief that Schwartz, or that the plaintiffs invited that error to the extent the trial court discussed Schwartz. Plaintiffs, by citing it, invited that. And then last, the trial court did properly discuss and apply, for lack of a better term, the substantial factor test as it relates to the unseaworthiness claims. And those are the 3 reasons why the assignments of error should be overruled. In addition, there are other grounds that if this court were to find that the trial court committed error in granting summary judgment on the causation basis, there are other grounds that exist that would justify and would suggest that this court should affirm.
But the trial court never got to those grounds, correct?
The trial court did not, but we cited the case that from this court, I believe, that says that this court can find, because it's a de novo review, this is the Cook Family Investments versus Billings case, 2006, Ohio 764, says that, and that's a decision from this court again, that says that you can affirm a summary judgment on different grounds than the trial court. I want to remind the court that we did file a motion to dismiss the appeal because we believe that the notice of appeal was filed untimely, and therefore this court lacks jurisdiction to hear that. I know that that's not the purpose here today, but the court in its order concerning our motion to dismiss did indicate that it may revisit that issue, and so I wanted to restate that U.S. Steel continues to believe, for the reasons set forth in its motions and related papers, that the notice of appeal was not timely filed in this case. There was a final appealable order that disposed of all remaining claims in the case issued on August 2nd, 2018, which required the notice of appeal then to be filed by September 3rd of 2018, and it was not. In short, that was the reason for that. But turning back to the assignments of error at issue here, again, the substantial factor test of Schwartz is the same substantial factor test that's been used in maritime cases as it relates to unseaworthiness claims. The trial court cited those. It was not improper to discuss that the Schwartz case has a substantial factor test that is almost identical, I believe, to the term the trial court used, to the tests in the maritime law.
Counsel, what about under the Jones Act count?
Yeah, well, that is a featherweight standard, and here the trial court, if you look first in the order granting the summary judgment on page A10 of the record, said that Shaffer's exposure, immediately questioned Shaffer's exposure to asbestos, if at all, is in question. That statement, that Shaffer's exposure to asbestos, if at all, is in question, is in the initial order granting summary judgment. Then on the motion for reconsideration, where the parties did have an opportunity to talk more about Schwartz, the court clarified that, this is a quote from the order granting or denying the motion for reconsideration. He says, putting aside Schwartz for a moment, no expert affirmatively opined that Shaffer's exposure to asbestos on any USSC ship directly caused his illness. And then finally, the court in that order concluded, using the language that appellant's counsel says should apply, the language of the causation test says, quote, Shaffer posited no evidence that his alleged exposure to asbestos caused injury to him, however slight. So that was a finding made by the judge based on the evidence before him, applying the proper test that appellant said should apply, the language of that test. And so it's very clear that when the court talks about there's no substantial factor, that the reason for that is because he finds no causation, however slight, at all.
Is circumstantial evidence sufficient to get past a summary judgment?
It can be, but it's not in this case, Your Honor. And here, because Mr. Shaffer was asked, and we have the citations to every time in his deposition, he was asked whether either a duty he said that he performed caused him to be exposed to asbestos, whether duties that other people working around him were doing caused him to be exposed to asbestos, whether certain materials or equipment that he specifically identified caused him to be exposed to asbestos. And in each and every one of those cases, and there's over 20 questions, if you counted them all up like that, he said that he didn't believe he was exposed to asbestos.
Well, was he qualified as an expert before he was asked those questions?
Well, those weren't necessarily... No, Your
My
Honor.
question to you is, how would he know one way or the
Your
other?
Honor, he wasn't qualified. Well, because these gentlemen, certainly in asbestos cases, frequently testify about whether they believe something contained asbestos or knew it because of the packaging, because somebody told them, because of training they received about the handling of those materials, because of some thing that they read while they were on the job. But here there's nothing like that. It's his belief. He has personal knowledge. This isn't an opinion testimony. This is about his personal knowledge and his personal belief. And it was no across the board. And therefore, when the experts that the plaintiff's counsel has referenced here, they have to base their opinions on facts that they are either have personal knowledge of or that are admissible in evidence. And here, there is no evidence of any asbestos exposure. We cited the Jackson versus AC Products liability case that is a federal maritime case and makes it very clear that the mere presence of asbestos on these vessels isn't enough circumstantial evidence to create a presumption of exposure or evidence of exposure. You have to have more than that. And the Jackson case is very clear on that. So, and that's exactly one of the arguments that's being made here is that, well, all of these steamships have asbestos-containing materials on them, and they did because they were required by the government to do so at the time. And therefore, that's evidence of exposure in itself, and the Jackson case rejected that premise. So the trial court did apply the featherweight standard to the Jones Act claim, and then when it got to the unseaworthiness claim, it referenced the substantial factor test, but obviously having previously concluded that there was no evidence of causation, then the substantial factor test was also satisfied. But even if this court were to find that the substantial or that the featherweight test isn't satisfied, the substantial factor test certainly is not satisfied here. Again, I refer back to the Jackson case where that was the issue, where the only circumstantial evidence, if you will, of exposure to asbestos was the fact that there was asbestos present on the vessel. But the plaintiff's testimony about working with materials was not enough in that case to create evidence of exposure. And the mere presence did not establish that. The experts do not have any personal knowledge. They didn't ever visit any of these ships. All of their opinions, if you look at them, are basically hypotheticals themselves. That if Mr. Shaffer breathed in the dust, then it was a cause, is what Spear and Maddox have language like that, if you look at the way their opinions are written. The Miller test, as it relates to unseaworthiness, is the case that I think the plaintiffs hold up as saying that substantial factor under Schwartz is different than substantial factor under maritime because of the Miller case. Well, the Miller case, what the defendants in that case were trying to do is say, plaintiff, you have to show a heightened standard. You have to show frequent, regular, and intense exposure. And the court said, no, you don't have to show that heightened standard. The court did not say that it's inappropriate to consider things like frequency, regularity, proximity, and those types of things that Schwartz talks about. It just says that you don't have to show that it was frequent or that it was intense. Those language does not appear in Schwartz. So that's the difference, is what the argument in Miller was, not the test that ultimately those courts applied. And as I mentioned, that there are some other grounds that if the court did find that the trial court was not correct in granting summary judgment on causation, it would be appropriate for this court to affirm summary judgment anyway, As it relates to the Jones Act claim, there's no evidence in this case that U.S. Steel breached a duty. The Jones Act requires that the ship owner, here U.S. Steel, have actual or constructive knowledge of an unsafe condition, and that harm from that unsafe condition was foreseeable to the ship owner at the time. The plaintiffs have absolutely no evidence of that. They cite some general studies about that out of the maritime context, that there were some awareness of asbestos risks. But U.S. Steel affirmatively put in evidence correspondence from its Director of Industrial Medicine, J.J. Schwerha, in 1987, to Dr. Urban Silikoff, who's one of the preeminent, and the plaintiffs will tell you this, preeminent industrial hygiene experts in the area of asbestos. And in 1987, Dr. Silikoff and Mr. Schwerha was trying to get his arms around, well, is there a risk to these merchant mariners on U.S. Steel vessels? And Dr. Silikoff, in that letter, and it's quoted there, but I'll paraphrase, basically said there's a dearth of information on this code.
See the evidence. Your time is up.
Thank you, Judge.
Thank you. Counsel, you're down to 40 seconds.
40 seconds.
40 seconds.
Quickly, you didn't hear any argument that the judge applied the right standard. I mean, obviously, the federal maritime law standard applied. Second, there's ample evidence, circumstantial evidence, through our experts and through the specs of the ships that these vessels contain asbestos. In fact, Mr. Mendoza just said that they contained asbestos. That wasn't even disputed. Of course there was asbestos. Because Mr. Shaffer, and we cited law that said Mr. Shaffer doesn't have to supply that evidence. It can be supplied from circumstantial evidence. The duty, again, we attached correspondence.
And counsel will have to look at that in the record. Thank you both for your arguments. We will take the matter under advisement. We'll issue a written opinion, which will be posted on our website, and that of the Supreme Court of Ohio.